A federal court has once again ruled that current laws banning the possession of machine guns may actually violate the Second Amendment. This case, which has now been pushed forward for oral arguments, stems from earlier legal battles where the federal government, even under the Trump administration, continued to defend these restrictions. What's surprising to many in the 2A community is that despite several promising rulings in favor of gun rights, the government, through figures like former Attorney General Bondi, continued to argue against these rulings, and although one of those arguments led to a significant win, the broader legal battle is far from over. Here's what's happening right now. Recently, a federal court dismissed a charge involving machine gun possession, citing the protections of the Second Amendment and referencing the Supreme Court's landmark decision in Bruen. This is a major development. In fact, there are now 2 separate federal district courts that have thrown out machine gun possession convictions for violating constitutional rights. The most recent came out of Mississippi, where Judge Carlton Reeves ruled in United States v. Bruen that such restrictions could not be upheld. That decision is currently being appealed to the Fifth Circuit, but today's focus is on a related case, United States v. Morgan, which is heading to the 10th Circuit for oral arguments in just a few weeks. In this case, a federal judge in Kansas also ruled that charges against the defendant for possessing a machine gun violated the Second Amendment. Even with this momentum, the government has decided to appeal. So now, the 10th Circuit will hear arguments on July 8th to decide whether the lower court's decision will stand. What's frustrating for many supporters of gun rights is that the federal government is still taking an anti-Second Amendment stance, not only in this Morgan case, but also in the ongoing appeal in the Bruen case. Unless there's strong public pressure, this position may remain unchanged, just as we saw with earlier legal challenges involving suppressors and various rifle bans, particularly those coming out of Illinois. The court in this case firmly rejected the arguments put forward by the federal government, at the time under the Biden administration. Specifically, the government attempted to rely on the Heller decision to justify the restriction on machine guns, but the judge found that interpretation unconvincing. The court emphasized that the weapons in question are considered bearable arms, and under the first step of the Bruen framework, they fall under the plain text of the Second Amendment. Following that, the court reviewed whether any historical tradition could justify the restrictions. According to Bruen, it's the government's responsibility to demonstrate a historical precedent for limiting the possession of such weapons. But in this case, the judge found that the government simply failed to meet that burden. What's important to understand is that the Biden administration, during that district court trial, presented very little historical evidence to support its case. Instead of building a strong argument rooted in history, the government focused almost entirely on claiming that machine guns aren't protected under the Second Amendment. Once the court ruled that machine guns do qualify as arms and therefore are protected, the government had little else to support its position. That lack of historical justification is what ultimately led to their loss in the lower court. After being defeated at the district level, the federal government appealed the case to the 10th Circuit, asking the appellate court to overturn the ruling. In response, Mr. Morgan and his legal team argued that the district court's narrow decision should stand. Early in their brief to the 10th Circuit, Morgan's attorneys pointed out that the government was now trying to introduce additional historical evidence that had not been presented earlier during the district court proceedings. This is significant. At the district level, the federal government had only submitted 2 historical examples to support its position. But in the 10th Circuit appeal, they attempted to bring in several more examples to try and strengthen their argument. Morgan's legal team has asked the 10th Circuit to reject all of these new materials, arguing that the appellate court's review should be based solely on what was presented in the lower court, not new arguments added later. Morgan's attorneys also reminded the court that this was an as-applied decision. That means the ruling was specific to Mr. Morgan and the unique facts of his case. The district court did not issue a sweeping judgment affecting all future cases. It left the door open for different outcomes under different circumstances. Now here's where things get even more interesting. Although the original appeal was filed during the Biden administration, the case is now under the control of the Trump administration. That means the current federal leadership has the authority to decide how to move forward. However, despite the Trump administration forming a new Second Amendment task force under Attorney General Bondi, They are still continuing to argue against gun rights in this case, and also in the Bruen case in the Fifth Circuit. In their most recent legal brief, the Trump administration argues that the district court was wrong. They claim that the federal law under Section 922, which bans possession of machine guns, does not violate the Second Amendment. Their reasoning? Machine guns, they say, are not commonly used for lawful purposes like self-defense, and the ban is consistent with historical traditions of regulating dangerous and unusual weapons. They also argue that Morgan failed to properly counter their points on appeal. According to the government, Morgan is wrong to suggest that they failed to preserve certain arguments. They claim the Supreme Court has made it clear. The Second Amendment does not protect firearms that are not typically used by law-abiding citizens for lawful purposes. Additionally, the Trump administration criticizes Morgan for promoting a legal standard that would require the government to prove early founding-era laws that specifically regulated weapons based on their rate of fire, something they argue is not required. In conclusion, the federal government is urging the 10th Circuit to reverse the district court's ruling and reinstate the conviction. So now, it's up to the 10th Circuit to decide whether to uphold the lower court's defense of the Second Amendment or to side with the government's continued effort to limit certain types of firearms. The Trump DOJ has also made similar arguments recently in the Bruen appeal currently moving through the Fifth Circuit. So even in that case, the Trump administration is continuing to push back against a lower court decision that struck down machine gun possession charges. It's disappointing to see that Attorney General Bondi, the DOJ, and the newly formed Second Amendment Task Force are still allowing these cases to proceed, either because they're being handled by holdovers from the previous administration, or because they actually believe that machine guns are not protected arms under the Second Amendment. My hope is that the 2A task force steps in soon and puts an end to these arguments. They've intervened in other cases before, so it's entirely possible to shift course, if there's enough pressure. But for now, the 10th Circuit is moving forward based on the arguments presented by the current DOJ. Oral arguments in the Morgan case are scheduled for July 8th, and once that hearing takes place, the court will decide whether to uphold or overturn the lower court's ruling. Please share this video to help spread the word. The more people who are aware, the more likely it is that the administration will take notice, just like they did in other high-profile cases, and step in to stop these anti-Second Amendment arguments. These are significant wins that deserve to stand, and letting them be reversed would be a huge setback. Upholding these rulings would open the door for similar legal challenges, especially as-applied challenges that could help dismantle other machine gun possession charges under the Gun Control Act. That kind of momentum could lead to broader change. Again, oral arguments in the 10th Circuit are set for July 8th. Unfortunately, as of now, the Trump administration is still actively trying to reverse the victory we saw in the Morgan case, and they're doing the same in the Bruen case before the Fifth Circuit. So all eyes are on these upcoming hearings. We'll be paying close attention to what is said during oral arguments and watching closely to see if the administration shifts its position. As soon as there are updates, I'll be sure to let you know. Thank you all for watching. If you found this video helpful or informative, don't forget to like, comment, and subscribe. Your support helps get this message out to more people.